So, dear students, let's start today's topic. So, the topic that we are going to start is very critical, very important, and very technical also. Uh, the previous topic we covered was sources of law. That was also one of the basic concepts of the law. But today we are going to discuss the court system of UK. Court system of UK. So it is difficult to memorize the hierarchies and structures in court system. It is a very technical topic, so you need to focus a lot. You need to memorize after every class what we have studied during the class. So unless doing so, it will be very difficult to understand this topic. So what are the hierarchies available to us? What is the court system in UK? So let's start with the hierarchy of the court. So the hierarchy is like it starts with the let's start with the lowest court. So the most lowest court is magistrate court. Then there is a crown court. After crown court, there is a county court. Then there is a high court. After that, there is court of appeal. And finally, the most important and highest level court, that is Supreme Court of UK. So this is the hierarchy. Magistrate court is the lowest court. Supreme Court is the highest court. So we have to go through all these courts one by one. We will start from magistrate court. We will discuss three things in every court: the structure and the judges of the court, the jurisdiction of the court, and the appeals of that court, the right of appeal. So these are three most important things to be memorized, to be studied in the hierarchy of courts. But before starting the court system, we need to understand one of the very important concept, which is which will create the basics, which is the core basic to understand why a case is moving from magistrate court to county court. So the concept that we are going to start with is there are a case is of two type, or law is of two type, we can say. One is called civil law and the other one is called criminal law. So what is the difference between them? So the civil law is there to settle the dispute between two parties for compensation. This is the purpose of a civil law or of a civil case. Whereas the criminal law, the purpose of criminal law is to penalize the wrongdoer by state. So to understand this, we must understand that what is a crime. So crime is a behavior prohibited by law. So crime is any behavior, act or statement that is prohibited by law, that is not allowed by law. For example, misrepresentation is a crime, robbery is a crime, theft is a crime. So these are the behaviors that are not expected by any individual in the society because it will create restless situation among the community. So because due to these sorts of behaviors, the dispute among the persons will create, social control will be disturbed. So these behaviors are not acceptable in the society. So that is why they are called the crime. And law defines the crime. So law defines that theft is a behavior that is not accepted, that is not acceptable by any means, and this behavior is prohibited. And a law basically nominates that act as a crime. So according to law, whatever behavior is prohibited by the individual is called crime. So whoever does such type of crime, or Mr. A is involved in any sort of crime, so the purpose of criminal law is to penalize that person. The wrongdoer who was engaged in this sort of criminal activity, he will be penalized, but he will be penalized by the state because law is made by the state, and by doing so, by committing that type of crime, he has violated the rule of state. So he has performed a behavior which is in violation of state. So state itself will penalize the wrongdoer. So this is the purpose of criminal law. Whereas in civil law, the purpose is very much different. In civil law, the purpose is to settle the dispute. So we want to settle the dispute between two parties, Mr. A and Mr. B. They have a dispute among them due to a contractual breach, due to a breach of tort, due to breach of unemployment or employment rules regulations. So there is a dispute between two parties. There is no state involved. So Mr. A has breached the rights of Mr. B. So A has breached the rights of B. So we need to compensate B. So A will compensate B. This law is called civil law. So it is a matter of settlement between the two parties. So this is the difference between civil law and criminal law. So take an example for that. For example, if for example A punches B, this is an event that occurred. So what will happen in civil law? In civil law, basically what will B do? B will sue A for the pain, medical expenses, and day off from office. The salary of the 2 days for which he has not been present due to this punch, because he was in hospital, he was getting treatment from the hospital. So that is why he couldn't attend the office for 2 days, so he will not be paid salary for 2 days, so he can claim this salary from Mr. A. So these are the losses that are suffered by B, and B will get settlement from A. So this is a case by B on A. This is a dispute between two parties, and the court will settle it by ordering A to compensate B because he punched B. So this will be a civil case. Whereas in criminal law, A was indulged in a crime because he punched B. So if everyone starts punching other, this behavior is not acceptable by law because it will create abuse of social rights. So this means that A is involved in a crime because he punched B. So this type of crime is called battery. This is a specific word battery, called for punch or damage to a person, injury to a person caused by the punch or any material touch to that person. So the law will create like that: prosecutor will sue A for the charges of battery. We will study this term battery in chapter 3. So battery is a physical injury, is a form of physical injury when someone hits with something to a person causing the damage is called battery. So prosecutor will sue A. Prosecutor is a legal representative. Prosecutor will case on A on behalf of the state. So prosecutor is an official personality nominated by the state in court for criminal cases. So prosecutor on behalf of state will sue A for the crime he was indulged in. So there are two types of cases. If A punches B, one is a civil case and the other one is a criminal case. So let's have another example. If A hit the car of B while over speeding, so what will happen? A has hit with his car to B's car and A was overspeeding. So there is a damage to B's car. He needs compensation for the damage to bonnet of the car, the headlights that have broken. So he needs compensation because it was A's negligence. He was driving by overspeeding. So what will happen? Now here B will sue A for car damage compensation. So here A has to pay the price of a new bumper or new headlight. So this is how this dispute is going to settle. So civil law, according to definition, civil law is here to settle the dispute between two parties for compensation. So compensation will be paid by A to B and the dispute will be settled. For example, A has paid $500 for compensation and now B will change his car's bumper and headlights. So the dispute is settled among the both persons. So this is civil law. But there is another case here, and that is a case of a crime. So over speeding is prohibited by law, by traffic rules and regulations. So he has violated the rules of traffic regulations. So what will happen? Prosecutor will sue A for the charges of over speeding. So this case is a criminal case and it is a matter between the state and Mr. A. And prosecutor on behalf of Mr. A, sorry, on behalf of state will sue A. So this is a crime conducted by A and prosecutor is going to sue A and the purpose of it is to penalize A so that it may not become habit of A or it can be created as an example for the society that no one is allowed to overspeed on road because it is not allowed. So this is a matter between state and A. Whereas on the contrary, in civil case, it was a matter between B and A, two persons. So I am hopeful that you would have understood the concept and the difference between civil law and criminal law. So let's discuss further concepts. For example, what is the compensation in both types of cases, or we can say what is the type of payment that is to be made. So in civil cases, the is compensation is in form of payment. So payment will be made by by A to B. So the payment will include payment for the pain when A punched B, payment for medical charges, payment for the salary which he was not able to obtain. So in civil law, the remedy is the payment. The compensation is the payment. Whereas in criminal law, the remedy is the fine, and in UK it is imprisonment. So if a person punches B, he may have to pay fine to the government, to the state, because it is a matter between state and the individual, or the state will imprison that person for 6 months, 1 year, 2 year, depending upon the penalties provided by the law. Or there can be a case that a person is also fined and is also imprisoned. So here the remedy is the fine or the imprisonment. So fine is paid to the Treasury Department of the government. Treasury Department of the government. So it is collected by the government because that person violated the rules of the government. So this is the difference. Another difference is the case name between civil law and the criminal law. In civil law, B sued A. So we will say this is a case B versus A. So the first name, that is B, who is going to sue A, is called claimant. He is going he is going to claim that Mr. A violated his rights. Mr. A was the reason of the damage to his car or the punch. So the case starts with the claimant's name, and the later name is Mr. A is called defendant. He will defend the case. He will defend the proofs. So the case name will be B versus A. First name is of claimant, the second name is of defendant. So B has sued A. So claimant versus defendant. For example, there is a case law called Fisher versus Bell. So these are two persons, Fisher and Bell. These are two individuals. So Fisher is the claimant who has claimed something from Mr. Bell, and this case is on Mr. Bell. So he will be called as the defendant. So there is another name. Instead of using claimant in some case laws, there is another name called plaintiff. In some previous cases before 19th century, in 18th century or 17th century, the books use the word plaintiff. So claimant is also called plaintiff. But nowadays it is called the claimant. So claimant versus defendant. This is a dispute between two persons. So Mr. B, Mr. X, Mr. Y, Mr. Z will sue A. So the name suggests that this is a civil case because these both are individuals. Whereas in criminal law, this is state versus A because A has violated the rules of the state. So state means the law, and law is approved by Queen because royal assent is provided by Queen, and in Latin Queen is called Regina, and the word Regina gets short and it became Rex, and nowadays only R is used. So the case name becomes R versus A. This means that if Mr. A's full name is Mr. Arnold and he has committed a crime, so the criminal case name will be R versus Arnold. R stands for Queen, and Queen is the ultimate authority of state. So basically, Arnold violated the rules made by Queen because Queen is a part of parliamentary system. Queen is the head of the state. So prosecutor will sue on behalf of Queen to Mr. Arnold. So that is how the name differentiates between a civil case and criminal case. So we can judge a case by its name. For example, there is a case, it is called Michael versus Nestle. So this is a civil case. So Mr. Michael has sued Nestle for the compensation of the loss of property. So this is a dispute between two parties, Michael versus Nestle. There is no R involved, there is no state involved. But there is another case that is R versus Harris. So the name suggests that it is a criminal case because there is R in it. So Mr. Harris will be involved in some sort of a criminal activity. That is why this case name starts with R. So by name we can judge whether it is a civil case or a criminal case. So I am hopeful you would have understood the differentiation between the civil case or civil law or a criminal law. Yes, the last thing about the differentiation between civil law and the criminal law is the burden of proof. So who has the burden of proof? What is meant by burden of proof? This means that who has the responsibility to provide the proof? Who has the responsibility to provide proof? So whether it's claimant's responsibility or whether it is defendant's responsibility. So defender defendant is defending the claims by the claimant. So in the eyes of the court, defendant is innocent unless he is proved of guiltiness. So the responsibility of proving the wrongdoing of a person rests with the claimant. So in civil law, the burden of proof is on claimant because the claimant has come to the court and he is claiming that Mr. B hit his car, so his car is damaged. So this is Mr. A's claim, the claimant, or this is Mr. B's claim. So the claimant is going to prove that Mr. A hit with his car on Saturday at 9 p.m. and due to that my car's headlight got damaged. So it is responsibility of claimant to provide proof to the court. So burden of proof is on claimant in civil cases, whereas in criminal cases it is the responsibility of prosecutor. So prosecutor is responsible to provide proof to the court that Mr. A was indulged in a crime. So by different sorts of proof or evidence like the fingerprints, like CCTV footage camera will prove that Mr. A was involved in a theft or a robbery. So it is the responsibility of prosecutor to prove the evidence in the court. This is called burden of proof. So these are the two types of laws, civil law and the criminal law. So let's start our main topic of discussion for today, and that was hierarchy of court means understanding the court system. So we started today with the differentiation between civil law and criminal law, but our main topic is the court system. So we can see there is a magistrate court, there is a crown court, county court, high court, court of appeal, and supreme court. So all these are the important courts. This is the hierarchy. The lowest court is magistrate court and the highest court is supreme court. So the hierarchy starts from magistrate court and it ends at supreme court in UK. So we will start with the lowest court, that is the magistrate court. So up until now we have we are able to differentiate between civil law and criminal law. So let's start with the magistrate court. So about magistrate court is basically a criminal court. It deals with the criminal law. Most of the cases that are heard here are criminal cases. So let's start with the structure of magistrate court, the judges of magistrate court. So magistrate court is presided by two types of judges. There are two types of judges in magistrate court: the district judges and the justices of peace. Justices of peace are also called magistrates. So these two types of judges are responsible for hearing a case in magistrate court. So what is the difference between the two judges? District judges are properly qualified judges. For example, they have attained a degree in law like LLB. They are properly salaried. They are properly salaried. They are the permanent employees of the court. They can hear a case alone because they are purely qualified, fully qualified. They know every aspect of the law, so they can hear a case alone. Whereas the justices of peace are not qualified, they are not even salaried. So, why they are working in the court if they are not qualified and they are not given salary? So, what is their motivation? They are actually studying the law. They will be the district judge in future, but during their studies they want to attain articleship or internship or some sort of experience. So to gain this sort of experience, they work as a justice of peace in magistrate court to gain experience so that they can write this on the CV, and they want to become the district judge in future after completion of their study. So yes, they are not fully qualified, they are actually partially qualified. They are during their studies. They are not salaried, that is right, but they are paid stipend as the ACCA gets stipend for the articleship. If they are pursuing an articleship in a firm, they will be paid as a stipend. So they are paid a stipend. As they are not fully qualified, so there are some legal clerks in the court, they help them on legal matters. They are available to Justice of Peace for support, for the legal support. So they give the legal support. As they are not fully qualified, so they cannot hear a case alone, and they will always sit in a bench of 2 or 3 judges. So these Justice of Peace hear the case in the bench of 2 to 3 judges at a time. So this is the difference between district judges and the Justice of Peace. So magistrate court is presided by district judges and Justice of Peace. These are the two types of judges, and they hear a case in magistrate court. So normally there is a district judge, and with that district judge, there is normally a Justice of Peace so that he can understand the rules of the court system. So they are actually okay. So they are actually learning the ways of hearing a case with district judges. So they are on internship, they are not fully qualified. So that is why there is a problem. So kindly wait for a minute. We will resume the class in a minute. So dear students, okay, so what we were discussing that there are two types of judges, district judge and the Justice of Peace. So after the understanding of the structure of the judges at magistrate court, let's proceed, and we will now discuss the jurisdiction of the court. So what is jurisdiction? Jurisdiction means the scope of the court. the scope of the cases which are heard at magistrate court. So which are the cases that comes under the power of or under the authority of magistrate court? So there are two types of jurisdictions because there are two types of cases. There are two types of cases, as you know, civil case and criminal case. So we will read the jurisdiction accordingly. So there will be two types of jurisdictions, criminal jurisdiction and civil jurisdiction. So criminal jurisdiction means the power of magistrate court jurisdiction. So criminal jurisdiction means the power of magistrate court to hear a criminal case. So what is the power? What is the authority of magistrate court regarding criminal cases? This is called criminal jurisdiction. So to understand this, we will start by the definition of criminal offenses. So we know that crime is an offense, crime is a behavior prohibited by the law. So we know that. So there are two types of crimes, mainly two types of crimes. There are summary offenses and there are indictable offenses. The first category is called summary offenses. These are two types of criminal offenses. First one is summary offenses and the other one is indictable offenses. So what is the difference between two? Summary offense is a minor offense, whereas indictable offense is a major crime. For example, minor offenses include misrepresentation, it includes abusive language, it includes aggressive behavior, so all these are the examples of a minor crime and minor crimes are called summary offenses. Whereas there are some major crimes that are called indictable offenses. For example, they include kidnapping, it includes rape, it includes robbery, it includes murder. So all these crimes are major crimes and they are called indictable offenses. So what we are reading, we are going to understand the criminal jurisdiction of magistrate court. But before this, we need to understand that a criminal activity or a criminal offense is of two types, summary offense and indictable offense. So one of these, the cases, among the cases, one of these will be heard at magistrate court and the other one will be forwarded to the next court, that is Crown Court. So the problem here is that the magistrate court only has the magistrate court only has the power to imprison for 6 months because this is a lower court and there are justices of peace in it who are even not qualified. So the power of magistrate court is very low, and it can only imprison a person for 6 months. So if we go back, what do you think, which offense will be heard at magistrate court? So it will be certainly summary offense, because summary offenses are minor offenses and they can be tackled within 6 months, whereas kidnapping, rape, murder, robbery, all these offenses are major offenses, and according to law, there is an imprisonment for these crimes for more than 10 years. So this means that magistrate court is not suitable for hearing indictable offenses because these are major crimes. So only minor crimes, the cases of these minor crimes are heard in magistrate court, whereas these indictable offences are forwarded to Crown Court. These are forwarded to Crown Court, which is the upper level of criminal jurisdiction, forwarded to Crown Court after preliminary investigation. So, definition of jurisdiction. Rahmatullah, jurisdiction means the power of the court, the scope of the court, the area under which magistrate court can hear a case. So jurisdiction means that indictable offences doesn't fall in the jurisdiction of magistrate court. They are outside the scope of magistrate court. Whereas the summary offences falls in the jurisdiction of magistrate court. So they are within the scope of, within the power of, within the authority of the magistrate court. So these types of cases will be heard by the magistrate court. So these summary offences are within criminal jurisdiction of the magistrate court. So what will happen here? The summary offences will be forwarded, the summary offences will be forwarded, the summary offences will be heard in magistrate court, whereas the indictable offences will be forwarded to Crown Court after preliminary investigation. This means that the preliminary investigation will be performed in magistrate court, but after performing preliminary investigation, the trial of that case will start in Crown Court. So what is preliminary investigation? Preliminary investigation means initial investigation by the police. So it means if police needs a warrant, a search warrant of someone's house, so they can come to magistrate court and they can get a warrant of indictable cases from magistrate court. They can have a remand order from magistrate court. They can have a post-mortem order from magistrate court. So they can get all these orders from the magistrate court, but the trial of that indictable offence will not start in magistrate court. It will be forwarded to Crown Court for trial purposes. So the hearing of case will start in Crown Court. Only preliminary investigation of the indictable offences will be performed here in magistrate court because indictable offences are out of the scope of the magistrate court. They doesn't fall in the criminal jurisdiction of magistrate court because magistrate court can only give imprisonment of 6 months. So they are out of the scope of the magistrate court because in murder there are usually 15 to 20 years imprisonment and magistrate court doesn't have power to give imprisonment of 20 years. So that is why this is out of the scope and this is out of the jurisdiction of the magistrate court. That is why it is forwarded to Crown Court, which has such power, which has a power to imprison, to give imprisonment for 15 years or 20 years. So that is why the trial starts in Crown Court. Only preliminary investigation, initial investigation will be performed in magistrate court. So I am hopeful you would have understood the criminal jurisdiction of the magistrate court. So if there is any inquiry or question, you can ask through chat. There is a third type of criminal offences as well. The third type is called either way offences. So what are either way offences? Basically, either way offences are the mixture of summary offence and indictable offence. So they are mixture of summary and indictable offence. They are not clear. They can be only summary offence, and there is a case that after some hearings we come to that conclusion that this is an indictable offence. So they are not clear at initial stages. Some of the attributes of the offence are minor in nature, but some of the attributes may become a major crime after that. So these types of offences are called either way offences. So what judges do here, they have option about either way offences. So they have option to treat them either as a summary offence, they will be called at they will be called either summary offence or they will be called as either indictable offence. So judges has these option. Judges can exercise their option. They can treat either as a summary offence or as an indictable offence. So if they treat this offence as an summary offence, its trial will begin in magistrate court. But if they treat these either way offences as an indictable offence, it will be forwarded to Crown Court as it was the case with normal summary and indictable offences. So we can see that summary offences are heard in magistrate court and indictable offences are heard in Crown Court after preliminary investigation. Same is the case here. Either way offences, if they are treated as either way summary because they are not clear, so if judge opt them as either summary offence, they will be trialed in magistrate court. But if they choose these cases to be either indictable offence, they will be forwarded to Crown Court as it was the case in normal summary offences and indictable offences. So if you are asking an example for either way offences, so let's write an example here. What is not working? Either way offences are not clear. Either way offences includes why it is not working. There is some problem with okay. Now it started working. So let's have an example of either way offences. So what is the example of either way offences? So according to law, the assault is an either way offense and theft is also considered as either way offense. So these are the two examples. Assault can be a sexual assault or a physical assault. So if you assaulted some person, so this can be initially considered as an aggressive behavior and it can be considered or opted as either summary offenses. But later on, when the trials begin, when the hearing starts, after that, if court discovers that it was not just an assault, it was an attempt of rape, but the person, Mr. A, didn't succeed. So it was initially an assault, and that assault was leading towards rape, but he couldn't do this type of criminal activity due to some problem. So the only assault was discovered. Assault was charged initially, but later on, court saw the evidence that he was trying to rape a person. So initially, it is an assault crime. It was initially started as an either way summary offense, but after that, it is considered it is a chance that the assault had an intention of rape as well. So, rape intention is not clear at assault time. It will be cleared after some hearings, after some discussions of lawyers or investigation by lawyers with the defendant. It will be clear whether he had an intent of rape or not. But initially, this is a case of assault. So it is a mixture of summary offense and it can be an indictable offense later on. So as we are not clear, so judge will decide whether he will treat it as either way summary or either way indictable. So if he treat this case as an either way summary, the trial will start in magistrate court, and if judge thinks that this is not only assault, it will have an element of rape in it, and it will be discovered later on, then he will consider it as an either way indictable offence, and he will forward this case to Crown Court. So I hope you will be clear on it. So this is the criminal jurisdiction of the magistrate court. So now we are clear that summary offences, the minor offences, are within the jurisdiction of criminal jurisdiction of magistrate court, but indictable offences are outside the criminal jurisdiction of magistrate court. They are heard by the Crown Court, and same is the rule that is applied in either way offence. If either way offences are treated as summary offences, they are within the scope of magistrate court, they are within the criminal jurisdiction of the magistrate court. But if either way offences are treated as either way indictable, they are outside the criminal jurisdiction of the magistrate court, and it will be heard in Crown Court. So this was the criminal jurisdiction of the magistrate court. So you can see these rules are difficult, these rules are technical, and you need to memorize these rules. Otherwise, you cannot understand the hierarchy of court. So it is very important that after class, in night, or in morning yesterday, you should revise these topics, you should memorize these important points. Otherwise, you will not be able to understand Crown Court or High Court or Court of Appeal or Supreme Court. So if you have not understood the magistrate court, you will not be able to understand the later courts in the hierarchy of court. So let's discuss civil jurisdiction of magistrate court. So civil jurisdiction means the power of magistrate court to hear a civil case. So we know that civil cases are for the purpose of settlement between the individuals for the compensation. So there are only three types of civil cases that are heard here in magistrate court, and these are family matter cases. If there is a dispute between a family members, then magistrate court will hear these cases. If there is a case of rent or charges, or we can say rent charges or bills, utility bills, or if there is a case of license, an organization has obtained a license to prepare beverages. So if the parent company and subsidiary company, or company A and company B, has a dispute for a license of a product, so they can come to magistrate court, they can file a case, and they can settle a dispute in magistrate court. So these are the three cases that fall in the jurisdiction of the magistrate court, but these are only civil cases. So there are only three civil cases that are tried in magistrate court. No other civil case is heard in magistrate court. So I'm hopeful that you would be clear on it. So once again, to revise, summary offences, if we discuss about criminal jurisdiction, magistrate court is only going to hear summary offences and either way summary offences. The indictable offences and either way indictable offences will be forwarded to Crown Court, whereas the civil jurisdiction is concerned family matters, rent, charges and bills, and license. These are the cases that are related to individual disputes for compensation, and only these three cases will be heard at the magistrate court. So a tenant may have a dispute with the landlord for rent purposes. There are some charges and bills related to electricity bills, telephone bills, mobile bills, internet bills. So if you have a dispute with your internet provider that he has charged you more than you were expecting or you actually utilized, so you can come to magistrate court and you can file a case to settle this dispute. So this is a civil case between two individuals or two organizations. So it will be heard in magistrate court. So the jurisdiction of magistrate court is complete. We have learned the criminal jurisdiction of the magistrate court and the civil jurisdiction of the magistrate court as well. So the last thing of today's topic and the last element of the magistrate court is the right of appeal. So everyone has a right to appeal. So if B sued A and court gave decision in favor of B, so decision is in favor of B. So A has right to appeal against B that the court didn't give right decision. So for this purpose, A has right to appeal in higher court against magistrate court that the decision was not right. So there are 2 points on which A can claim that the decision was wrong. First of all, the decision was wrong on the basis of facts, or otherwise, the decision was wrong on the basis of application of the law. So, when a person is going to appeal a decision or verdict of magistrate court, he can appeal on the basis of point of fact. Point of fact means a person is going to appeal on the basis of facts, that facts are not basically rightly or correctly presented in the court. So facts are not right. The factual findings are not correct. This is not my license. This was not my car. I was not on the road. I was in America. I was traveling through bus. So I was not present there. So the facts are wrong. I am not the employee of Nestle. So these are the facts. So if you are appealing on the basis of facts, that facts are not right, facts are not gathered correctly. So on this basis, you can appeal against magistrate court's verdict in Crown Court. So the case will be forwarded to Crown Court on the basis of point of fact. But if you are clear on point of fact and you think that the application of law is not clear, the act's penalties are not correctly applied on me. According to act, I should be given charge for level 5 fine, or I should be imprisoned for 3 months according to the act. But judge gave me imprisonment of 6 months, so this is not right. This is not the right application of law. So the act is not enforced accordingly. The act is not enforced appropriately. So if you consider the decision or verdict of the magistrate court as an inappropriate decision due to the wrong application of law, so you can have a right to appeal to the High Court. So you have two rights to appeal. The first right of appeal is on the basis of point of fact. So if you want to avail the appeal on the basis of fact, you can go to Crown Court. But if you are okay on the basis of facts and you think that I am considering this verdict inappropriate due to the law, then you can avail the appeal of point of law, and this case after magistrate court will be forwarded directly to high court on the basis of point of law. So this is the hierarchy of the appeals. So is there any question related to rights to appeal or civil jurisdiction? You can ask it. Okay. So what we discussed today was very technical, very important, and needs to be memorized, needs to be saved in your mind. So it's just not reading. It is about reading, getting the concept, and memorizing the rule. So these are the rules. So rules are very clear. So what are the rules? Rules are that magistrate court is presided by two types of judges. It is basically a criminal court. There are two types of judges here, district judge and justice of peace. The criminal jurisdiction or the criminal authority of magistrate court is restricted to minor cases only. So only summary offences, and either way summary offences are heard at magistrate court, whereas indictable offences and either way indictable offences are forwarded to Crown Court after preliminary investigation at magistrate court. So this is important. What is the civil jurisdiction of magistrate court? Only three cases: family matter, rent charges and bills, and license. So any issue, any behavior, any problem that needs settlement, that needs compensation between two parties, it will be considered as a civil case, and this civil case will be forwarded to magistrate court on the basis of family matters, rent charges and bills, and license. Then finally, we discussed the right of appeal. If a person is not happy about the case, about the verdict of or the decision of the court, so he has the right to appeal. So on the basis of appeal, he can forward the case, he can utilize his right to appeal. So he can, on the basis of the point of fact, means on the basis of facts, he can avail the appeal to Crown Court. Otherwise, if he's okay with the facts, he said, yes, I was present there, but I should not be penalized under Sales of Goods Act, or I should not be penalized under Human Rights Act because Act is not applied correctly. So, on the basis of application of law, you want to basically uh, file an appeal case, so you need to go to high court to file that case. So these are two types of appeals that are available, so you need to memorize all these things, otherwise it will be very difficult to understand Crown Court or high court in the next class. So these are important matters. This was a little bit of more technical than usually it is, and these are the conceptual elements of the law. So please, this is my suggestion that you should memorize these things. So if there is any inquiry or query related to anything, you can ask me now or you can ask me in WhatsApp group. So I will be available. So if there is no question, okay. So there is a question that point of law explain again, sir. So yes, we can discuss it uh, with an example. For example, Mr. and Mrs. John left 4 years boy home alone for 2 days. So this is an event that occurred on last Saturday. So there is a case on Mr. and Mrs. John that they left 4 years boy home alone without any reason for 2 days without any supervision. So these are the violation of rights of a child. So what are the matters of point of fact in it? And what are the matters of point of law in that event? So point of fact relates to the facts of the case. So 4 years boy, 2 days, Mr. and Mrs. Jones. So we have to confirm these things. So to confirm these things, to confirm the age of the boy, we can see the birth certificate that whether the boy is of 2 years or not. To confirm the days, we can get evidence from the neighbors that the boy was alone for 2 days. They are the witness. And so, for example, these are enough for point of fact. So, according to point of law, there is an act in UK that is called Child Abuse Act. So, according to that act, if the parents left home alone a boy for more than 3 days, so they are guilty of penalty. So this is a crime according to Child Abuse Act. So if the verdict of judge is against the parents in this case, so they agree that facts are right, age is right according to the birth certificate, neighbors are saying okay, they are right that we left the boy for 2 days. So we have no problem on point of fact, but we have problem on the application of law. We have been penalized by the court, whereas according to law, we should be free. We are not in violation of the law because according to law, the 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 parents, if they have left the boy home alone without any supervision for more than 3 days, then it will be considered as child abuse. So they think that they are not indulged in child abuse because they left home the boy for only 2 days. So they would want to appeal on point of law only. They are okay on point of fact. So is it clear now? So that's all students for today. So take care of you, stay home, stay blessed, and good night.